Well, hello everyone. How are you doing today? Yeah, my voice is not fresh. I haven't had a chance to do any warm-ups. I'm basically sandwiching this in between the plumber and the exterminator. Joys of being a homeowner. Yeah, I just spent $2,700 on a plumber. So, oh my God, I do not have any money, which means I'm going to have to do some other things to bring in money, which means not YouTube because I don't make that much from these videos. So if you want to help out, keep me doing this as much as I can, donate.pagosity.tv. Yes, I don't beg for money this early usually, but man, one thing after another. Now, if you haven't seen my video, News Cartels Destroy Privacy, you might want to give that one a watch before watching this one. The quick summary is, this is basically New York Times versus OpenAI. The plaintiffs are a lot of other news organizations as well, so they do that et al. And it's not just OpenAI, but it's Microsoft, and I think there are a couple of other defendants as well. But we're in the discovery phase. And ChatGPT has these options where you can say, get rid of my conversations. I don't want to keep them around because I don't want to keep them on your server. And that's a privacy thing, and that's important. But nope, because the news plaintiffs said, no, they have to turn everything over to us, and they need to stop deleting things like these conversations. And we covered their response to that and why that's a bad idea. But nope, the judge said you gotta preserve them. Now they can take them off the system itself and segregate them over here. But still, that's people's individual and business conversations there that could potentially just be turned over to the plaintiffs. So they're not just grabbing information from big corporations like OpenAI and Microsoft. It's from the little guy. It's from small businesses. It's from people like you and me. That's your conversations that they want. If you've got any conversations in there, they want to be able to say, oh, we want to be able to look at all that. And remember, these are news companies. Do you want the New York Times to be able to rife through everything you've said and done on ChatGPT? Even if you're not doing anything wrong, you don't want the news snooping in on your life. That's really important, and consider this. Would you have even known about it if it hadn't been for me covering it? That's why it's important. That's why it's important to donate. That's why it's important to share this video. Fortunately, at least one company, I think they're a small business, I'm not really familiar with them, but Spark Innovations Corp. They found out this was happening, and they're wanting to object to it in court. So this is them, Spark Innovations, creating mobile solutions for real-world problems. I think what they are is a product design company, because they don't just have game stuff. You look down here at the bottom, they've got jewelry too. But Gig Game Corp is a subsidiary of Spark Innovations, and that's going to be important as we go through this. So let's get into this motion to intervene by Jason Bramble. I, Jason Bramble, president of Spark Innovations Corp., respectfully submit this motion to intervene so that we can object to the retention and preservation of business data generated by my company and its subsidiary Gig Game Corp. Through the use of OpenAI platforms, including ChatGPT. We're a software consulting company that, through its wholly owned subsidiary Gig Game Corp., uses OpenAI's services, including ChatGPT, in proprietary workflows. Our use of these tools involves the input and generation of confidential, trade secret, and competitively sensitive business information. Additionally, we use these tools in the development of IP and solutions for our clients, whose data and interests are also potentially affected by this order. This includes, but is not limited to, the use of ChatGPT to aid in the drafting of patent applications, trademark requests, source code, and other forms of intellectual property filings. We are not a party to this litigation, have no involvement in the claims or defenses being litigated, and have not consented to any discovery or preservation obligations related to this proceeding. So on May 13th, this court issued a preservation order directing defendant OpenAI to retain and segregate all output log data that would otherwise be deleted on a going forward basis. This order has the effect of preserving private and proprietary data belonging to non-parties such as Spark Innovations Corp. And Gig Game Corp. Without notice, consent, or legal process. They're not a party to this. They're not a part of this lawsuit. And yet their information is going to be turned over to the news cartels. Not surprising then that they have a problem with that. The output log data being preserved includes confidential business operations, trade secrets, source code, and intellectual property developments of Spark Innovations Corp. And its subsidiary Gig Game Corp. Retention of this data creates ongoing risk of exposure and interferes with our internal policies and legal obligations related to data minimization, privacy, and intellectual property protection. Neither plaintiffs nor defendant OpenAI represent the specific privacy and confidentiality interests of third-party commercial users. And that's individual users as well as businesses like them. Because we've talked about people using ChatGPT for therapy purposes, even, in helping them fill out police reports, just as an aid to therapy, helping them keep a log of everything and keep their thoughts straight. And actually, I think the story we were covering actually used Gemini, not ChatGPT, but I'm sure people are using ChatGPT for that. Their own personal and highly sensitive thoughts being given to this AI. And so they go in the settings and they say, hey, ChatGPT, this is all a lot of personal stuff. I don't want it being preserved. When I delete this conversation, delete it from your servers. Well, now they can't. Well, they can delete it from their servers, but they still have to segregate it and turn it over because the judge told them to. I don't think she exactly ordered them specifically to turn it over, but make it available to be turned over if that's what she decides they need to do. All our personal private conversations. Here, the common question is the legality and scope of preserving ChatGPT output log data. Our interest in protecting our confidential data and ensuring it is not properly retained or disclosed overlaps with the questions before the court regarding the retention of such data. And remember, I'm going to say it again, they're talking about giving this data to the New York Times, to the news. Do you want the news getting your private chats? And like I said in the previous video, it's not just about AI, it's the whole legal system. This is actually how they can destroy privacy. And none of those privacy policies and everything mean a damn, no matter how good the company is about following them. Oh yes, we'll delete your data, and judge comes along and says, no, you won't. Like, okay, guess we won't. Just because a bunch of ambulance chasers said to. So they request that the court permit intervention for the limited purpose of objecting to the application of the preservation order to non-party data generated by Spark Innovations Corp. And Gig Game Corp. Alternatively, issue a clarification or modification of the May 13 order excluding from preservation data tied to users or entities not named in this action and not the subject of a lawful subpoena or discovery request. Would you think that would be like a natural automatic thing they would do? It isn't. Hey, we've got third-party data here. Who cares? Turn it over. But there's like private data here. There's private conversations, potentially even private medical data and therapy conversations and things like that. Don't care. Turn it over. That would be the best thing for the rest of us. Because then it wouldn't just be about Spark. It would be about, okay, we're not going to get any third-party data unless specifically there's a subpoena for it. But you know what the ambulance chasers want to do? They want to troll through it, looking for these happenstance little phrases that just happen to match or at least be close to something in one of their books. They go, aha, see, it's passing on their intellectual property, it's privacy, it's passing on copyrighted information, it's copyrighted, and we need to shut them down because they can't do that, and they need to pay us $1 jillion in licensing fees. Absolutely ridiculous. In the event our data is to be retained, require OpenAI to notify affected non-parties and provide an opportunity to opt out or seek protective relief. Just tell us about it. Because like I said at the beginning, if it weren't for me, would you have known about this? And what can you do as an individual? How many of you can afford to get a lawyer and go send out your own order there? How about notifying us and letting us know? It would seem to be the least you could do. This court's preservation order, though well-intentioned in service of discovery, yeah, right. You gotta suck up to the judge, though. You can't say, hey, judge, you're a corrupt Dumbo, you did wrong. No, you gotta use phrases like that. Risks overreaching into the private affairs of third parties with no stake in this litigation. Intervention is necessary to protect our rights and ensure judicial orders do not impose obligations on those who have not been heard. Hugs and kisses, Jason Bramble. Yep, lots of respect to bramble and spark innovation for doing this, for being so far the only one to stand up for themselves and kind of indirectly standing up for the rest of us. Because this might at least alert to the judge like, hey, there's a lot of personal information there. So we'll see what Judge Ona T. Wong does, considering how quickly she just rolled over to be a lapdog for the New York Times. I don't know. We'll see. We'll see how this goes. I don't think as much of the judge in this case as I do of Vince Chabria over in Cadre v. Meta, but we'll see how it goes. Maybe she'll surprise us. Hopefully she will, and hopefully the rest of us will get some protection from this horrific grab at our private data. And remember, who was the one who told you about this? How many other channels are covering this on YouTube? None of them. It's just me. So if you appreciate it, please, comments for the comment god, shares for the share throne, like, subscribe, the bell, and share this. Let people know this is happening. Because if the judge doesn't require them to notify everyone, we don't get notified, other than through videos like this. So share it everywhere you can. And again, donate.pagosity.tv. Please help me as much as you can, whether a one-time donation or becoming a regular supporter. Thank you so very much for watching. Until next time, stay strong and be free.